right now, you're the judge. You judge the law and the facts, and the judge has actually acknowledged that. That is the fact. On the night of September 24th, it was my understanding that I had the duty and the right and the obligation to enact a citizen's arrest to protect my family, based on the imminent situation I was in, my training. And I voiced my intention of the citizen's arrest immediately. The fact is, the citizen's arrest was my only tool that I had to contain the situation. I couldn't rely on law enforcement. The man was not going to stop shooting. My pets were in danger. And yes, even though at the scene, at the moment, I didn't articulate it, hey, you're shooting at my wife, I knew she was being shot at. And yes, true, I didn't get on the phone and immediately, are you okay, Pat? But I knew she was in danger because I saw where she was as I was crossing through. And when I saw Mr. Laxton, I knew she was in danger. And even when the prosecution played the second video, which I did object to, it was prejudicial, because it seems to try to plant a seed of doubt as to my credibility. What is he doing saying hi to these things? Well, Mr. Jones, I think, clarified that. The reality is that my family was attacked. My intention to hurt no one. Steal people's property? No, not a thing. To deprive them of their liberty, to stop them from killing my family and my pets. Plain and simple. I fired at no one. I fired at the ground. I was too far to reasonably take a shot at them to protect myself. I never had to shoot a gun at anybody. I never had to draw my gun in all the years since 1991. I've never had to draw my gun. And all the time flying, all the time in the inner city of Memphis inspecting property, never had a problem. The only legal remedy I had at that moment to protect my family at that moment was to enact a citizen's arrest. Now the facts show that Mr. Laxton's statements that he was, well, he said himself he wasn't in fear when he was over there cutting the grass. The reality is, he had the opportunity to go inside and call the police, call me. Say, hey, your dog's over here. Great, I'll go get him. You know, that's what neighbors do. As we've had dogs come on our property, even neighbors that we know don't like us. We see their tag, we call them, hey, Mr. Kirk, your dog's over here. Yeah, I'll meet you at the gate. There's your dog. That's what neighbors do. Whether you like them or not, they're their pets. It's like your children. It's one thing to complain about your neighbor, run for office because you don't feel like your voice is being heard, or that the people in the community are getting a fair shake, or that justice is being served. You try to step out of the boat. Sometimes a lot of people get upset. The reality is, sometimes these people go to extremes. And in this case, the extreme was Mr. Laxton, who was not in fear. As he wants you to believe, he's not in fear when he is cutting the grass and sees the dogs. He's not in fear when he goes in the house. He's not in fear when he comes out with a rifle. He's not in fear when he crosses the street. He's not in fear when he sees Brandy. You spend a lot of time in that room. I spent a lot of time right there arguing to get evidence in. But you didn't get to see. There's some evidence that's marked as exhibits for identification purposes only.
Objection, Your Honor.
The objection will be sustained. Ladies and gentlemen, again, we have to operate within the rules of evidence. That is, the rules of evidence determines what is admissible and what can be considered by a jury. And those are matters that I have to rule upon. And in order to preserve my rulings, if I rule that a piece of paper can't be admitted or shown to you or something of that effect, I ask it to be marked for verification purposes, so if necessary an appellate court can look at it and know what I ruled about. So that's the reason some things may be marked for identification purposes. things that are admitted into evidence are marked as evidence, such as a piece of paper that's admitted that you've looked at that you can consider is marked as an exhibit and is considered part of the evidence. Go ahead, please, Mr. Parsons.
Fact is, in the appellate court, there's no retrial. They don't review everything. They just look to see if there are errors in the lower court. Only if errors were performed and substantial errors do they reverse. They do not second guess the verdict rendered by a jury. The reality is, the statements that Mr. Laxton made, that he was in fear. As Mr. King so eloquently put on the video, Brandy was seated.
Objection, Your Honor. Objection.
She didn't charge.
Objection, Your Honor.
She didn't write.
He's testifying about matters not in evidence.
I spoke about it from the stand.
The jury can consider those things that were admitted in court, and you have to make your decision based upon the testimony of the witnesses in court. And it's up to you to recall what the witness, Mr. King, testified about. Go ahead, please.
She didn't lie. She didn't charge.
Objection, Your Honor. He is
I testified
arguing his testimony as to what he heard is
I'm
inadmissible.
testifying to what I saw. I testified to understand. I won't testify about that video marked as an exhibit on the table over there. I know I can't do that now.
Okay, ladies and gentlemen, again, it'd be up to you to remember what the different witnesses said. You have to make your decision based upon the testimony. It's up to you to determine the accuracy of all witnesses' testimony. Go ahead, please.
When we first started this conversation back on Thursday, I talked about illusions. Perception is that. Perception. Truth is the truth. The prosecution is painting a picture. The reality is, there's a lot of things that you don't know. I wish you did know. That evidence that he played, I think it actually helps me because you can hear me say, in fact, the man shot at me, he was shooting at Brandon, and bullets flying past me. I didn't even know that record was on me. But consistently since day one, I've said the same thing because it's been happening since day one. I've not changed. I've not altered anything. On the stand, they testified that at the probable cause hearing, they said in court that you said get on your knees, put a gun in your head, 6 barrels of barrel of gun. That's what came out, not in their statements. They read their statements. Their statements said nothing like that. And he says, but that's okay. They can forget about stuff that happened in the heat of the battle. But I can't. I can't not remember that my wife was shot at. If I forget to say, you're under citizen's arrest, Tennessee Code annotated 39-17-30 whatever, then I'm somehow guilty. I don't have the right to tell a person that because I'm not a law enforcement officer. You do have, if it wasn't there, we wouldn't be having this discussion. We are citizens, we're not subjects. I hope we never become that way. The fact is that government employees work for us. Hopefully, will continue to work for us and not work to our demise. The reality is that when a man crossed the street, went on a hunt with a rifle that was not originally fitted with a 30-round, 50-round banana clip, but with a 10-round clip, which is what a hunting rifle comes with. But in essence, what's classified as an assault weapon clip, or magazine, proper terms. His intention was to inflict a lot of ammunition really quick. You know, hunters don't clear this. People that go target shooting, camp shooting, stuff like that. Maybe people that want to just create a lot of damage on the Nick King testified. He had a .40 caliber in his pocket. True enough, Laxton never said what he had in his pocket. But I testified the man had something in his pocket that was pointed at him. Now, when I walked out and said you're under arrest, citizen's arrest, of course I preceded that with drop your gun, put your gun down, seeking to eliminate the threat. And once the gun is gone, there's no threat. And of course, not knowing where the rifle was, I inquired, where's the rifle? Where's your gun? Where's your gun? Where's your gun? Over and over and over. Finally seen the rifle, I picked it up. This time they're at the back of the hangar and they disappeared. They're in such fear that they're able to make a 911 phone call. In such fear, you know, they've got a gun to their head that they want you to believe, even though they didn't write it down, even though they didn't testify to it, to the officers. They never said to the officers, you got a gun in this pocket, got a cell phone in this pocket, pull out a phone, because I'm in fear of my life. He wasn't in fear of his life. He was calling and complaining. And I wish you could hear that video. I wish you could. When you enact a citizen's arrest, you have certain responsibilities that go along with that, but you also have certain legal protections. In the process of containing a dangerous situation, by doing something that would otherwise might appear to be illegal, but when you're stopping a person who's committed felonies in your presence, they have no expectation of rights at that point. It's the same standard an officer has. Because we, the people, have established police in the community to assist us with these things. We've granted them the authority that we ourselves have. We've not relegated this authority and denied our own selves. That's why we still have a Second Amendment, because we hold the power. We hold the eminent right to control government. That's why there's elections every so often. That's why we vote for laws and stuff like that. Some laws get changed periodically because they're viewed as not good now. They were good then, but they're not good now. Citizens' arrests have been on the books since Magna Carta because the king understood it, and the sheriff. The sheriff's been around 1,000 years. The sheriff sought out the neighbors to look out for the community. If they saw somebody breaking law, get a hold of them, seize them, bring them to me, and then we'll take it from there before the judge or the king or courts. There's citizens' arrests that happen every day in this country. It doesn't make the news because the prosecutions throughout the country, they don't want you to know you have that right. There's so many things that you have the right to do that I talk about every day on my radio show that people just don't know. In this audience, there are several people that do not pay federal income tax because there's no law that says you have to. He's not in here now, but there's two people that I know that don't even have driver's licenses or tax because in Tennessee, there's no law against traveling, only if you're a commercial carrier. Most people don't know that. Funny thing, people realize that everybody else does this, so maybe I have to do it too. It's like taking shots. The reality is that you don't have to. You ultimately make a choice over your health care. And that's the way it should be. You're individuals. You should have the right to decide your destiny as far as what you do. But because most people don't know the laws are there, this is one. Many people probably never heard of cases where you may have, you may not have. It happens quite frequently. At least if you watch the news in Shelby County, you hear about it all the time where people stop a criminal and the police go and assist that person. But it all depends on who the person is that's trying to stop the offense in this case. There's a huge difference between confiscation of a deadly weapon and burglary of a vehicle and theft of property. Picking up an assault rifle and a paddle to present to the police to let them know, yes, this is the gun you should be used to shoot me. And this is the paddle holster which fits the handgun that the other person had that was pointed at me. These are things now that you take, officer, and investigate And then when you're ready, I will come down and swear out the warrant, or I will go with you to effect the arrest. It's that simple. It's no different than going down and filing a complaint, but the ability for you to stop the threat right then protects you and your family. You have that right to stop the threat right then. And of course, many people I was talking to said, well, if it was me, I'd just shot him. Many law enforcement officers said, I just shot him. We teach people and train to just shoot them, that way you don't have to end up in court with your own. But I think we can do better than that. I think we can apply common sense and reason and not kill people. I think if the word gets out that, hey, you better not try to enact a citizen's arrest. If somebody threatens you, you better kill them. Otherwise, you'll be like Mr. Parsons, and you'll be locked up for 25 years. Well, depends on what kind of community you want. Common sense and reason, the ability to utilize the tools we have before us, or no common sense for people to just kill everybody because they're afraid of what the prosecution is going to do otherwise. I think we need all options we have before us to stop a threat without anyone being hurt. What am I accused of? The results of enacting a citizen's arrest. Why did I do that? It's really the only tool I had. Why not call the police? Well, as I said earlier, when seconds count, the police are literally, in my case, minimum 30 minutes away. And the question is, what is a citizen's arrest allowed you to do? And of course, reading the statutes here while you're away, hopefully you'll get to read it. And if it goes beyond my understanding, it's what it says. You don't have to be an attorney to understand what words mean. It's really not that complicated. I might want you to think that, but it's really not. It allows a citizen to take measures to contain a dangerous situation and protect themselves and their family and property. The things that most people here today that are not witnesses, but people in the audience that have been listening have asked me, is that while you're down there telling these people that you're under arrest, King makes a statement, I don't give a sh. And I tell them I'm making a citizen's arrest if they broke the law. And I tell them to get rid of the gun, pull it out, put it on the ground. I said, you're under arrest, dude. You have to stop. You understand? You're under arrest. Laxton says, you ain't got no authority to make an arrest. Does that sound like somebody who's in fear? Oh, and then King, the recording on 911, you know, he's making a phone call. He didn't get to do that either. 911 recording. And then Laxton says, when you get the law down here, don't worry about it. You should keep the SOBs up. You leave that rifle alone. And then I confiscated a rifle that was used to shoot at me and my family. Now, the state has to prove beyond a reasonable doubt that I did not act in self-defense. And the state has to prove beyond a reasonable doubt that I did not try to effect a citizen's arrest. If they cannot prove these things beyond a reasonable doubt, then the jury must find not guilty. There's something called mens rea. And if you did not have the mens rea for the elements of the crime herein, you must come back with a verdict of not guilty. All elements have to be met. These are serious charges. They have serious elements. they include the intent. What was your intent? Were you trying to steal something from them because you needed the money? Were you mad at these people and you're trying to attack them and assault them? No, I'm trying to stop the threat. I don't even know these people. I thought it was somebody else who I met once or twice. Thought was a good neighbor. And the aggravated kidnapping, that's amazing. Moved to confine another unlawfully so as to interfere substantially with the other's liberty and while in the possession of a weapon and knowingly, well, here it is. If you're making a citizen's arrest and you're acting in self-defense, all that goes out the window. Once you tell the person you're under arrest, they're supposed to submit. Now, of course, I never touched them. I never shot them. I had no wounds, no nothing. Because I wanted to stop the threat. Certainly I wanted to make the arrest. Wanted the police to come and arrest him. I testified as much to the officers. I want to have these people arrested. I'm acting a citizen's arrest. I shot me and my wife. Here's the rifle. This is what happened. Help me arrest these people. But that's not what happened. Because the officer doesn't believe that if the pistol's in a pocket and it's pointed at somebody, that's a threat. It's a threat. And of course, the farther they got, the less the threat. So as they were at the back of the building, when I picked up the rifle, then it was clear for me to run the other way, and I ran the other way. No, I didn't call the police right then because they'd already been called. I knew they were on the way. I said, yeah, tell them you're under arrest, citizen's arrest. Well, that didn't happen. Aggravated assault, if intentionally knowingly cause others to reasonably fear any bodily injury and the use of deadly weapons. Again, in making a citizen's arrest and acting in self-defense, that goes out the window. There's no expectation. It'd be like Jeffrey Dahmer murdering somebody and then having them charged with assault because they poked him in the eye while he's trying to kill him. That's not the way it works. He crossed the street. He's shooting at my dog, shooting in the direction of my wife. Now, did he know that my wife was there? Probably not. But you had a standard of care. When you're out hunting, and when you're shooting a gun anywhere, you are responsible for where the bullets go. And ultimately, you have a standard of care you must take in order to assure that there's nobody in the vicinity that can be harmed. He didn't do that. He was reckless. It's called reckless endangerment. Then when he's shooting at my dog, thinking it's a wolf, the men's very word term comes up again, I'm learning about it. It means what's in his mind. It means that if he shoots at a dog, he thinks it's a wolf. Not a full-blooded wolf. And he kills it. He has in effect committed a felony. Aggravated assault, reckless endangerment, and reckless felony animal cruelty, killing of a wolf. 3 felonies. It's just like the person that gets on the computer and looks up 14-year-old girls to have affairs with. Even if he's talking to an 18-year-old undercover officer, he's committed the crime of statutory rape or contributing to the delinquency of a minor. He's charged for that, and that sticks because it's what's in his mind. What was his intention? Mr. Laxton's intention was to kill a wolf. He wasn't afraid of it. If the dog is at the wall in his mind, Brandy in this case, my dog, and she's no threat at this point, but he continually moves forward to her until the point where she turns around and hello. When did he become the aggressor and just her presence, he pursued her. There's no threat to him. Theft of property again. I was securing the scene. And pursuant to the citizen's arrest, which has been said throughout the trial, I confiscated the rifle and the holster. Immediately gave it to the police. Burglary of a vehicle. The vehicle was right there with the weapon, right there where the citizen arrest was occurring, right there, at that time. And I have a duty and obligation to effect a confiscation of the rifle. And actually, in a citizen's arrest, if he would have went into a house, this is pretty interesting.
Objection, Your Honor.
Objection be sustained.
You go far beyond what I did. The bottom line is that Mr. Laxton, he clearly left the safety and security of his own property to attack or to attract the attention of my dogs. Had you only seen the video, which he saw playing in the pond across the street from his property. If he were truly concerned for his safety, which he states under oath, he could have called the sheriff, he could have called me, he could have called animal control. Instead, Mr. Laxton walked across the street off his property, baited my dog to approach him, but you never saw the video. Fired at them repeatedly and killed Brandy in the process. After Mr. Laxton recklessly fired in my direction, and of course killing my dog, he was then posing a threat, of course, when he was shooting in the direction of my wife, as he was standing and shooting in this direction, he posed a threat to her. I witnessed all this. I testified to it. This was not Mr. Laxton's property. This was my next door neighbor's property. And Mr. Laxton shelled 29 shots in the area. I think it was 89 houses within a mile of that property going north of the county line, which we're right on the county line, so don't tell me how many houses to the south. That was reckless. And as he shot up in the air, but supposedly that's not supposed to be reckless. I don't know. I think it's a double standard here. He showed absolutely no restraint. But did I fire back? No. Because reasonably, I was too far to be effective. But I wanted him to stop, so I shot at the ground. Hoping if he's not responding to my yells, he'll respond to a gun blast fired at the ground. And in the process of conducting a citizen's arrest and securing his weapon, which was used with permission and felonies by Mr. Laxton, and an accomplice, Mr. King, who did instruct Mr. Laxton to hide his rifle, and he didn't get to see the video. It's that first thing they write down, and it's that video that they made the next day. That tells the story. All this other stuff about get on your knees, and all, that was manufactured. None of their signatures were on those statements. Only police officers. They had to build a case. They testified. They never called me back. They never came and looked at the dog. Mr. Nessie dropped the ball, whether he was told to, whether he did it on his own. He spent just 30 minutes looking for Brandy after they had taken him away from the property, but spent 3 hours, as he testified, preparing the video, creating their story, just how they wanted. No interview with me, never took my story. And folks, these facts, along with an apparent number 7 jury tampering, should never have been there. Refusal of the court to provide a qualified public defender at the last moment, allowing her to withdraw. And yes, we've communicated, and yes, I've been given some very small amount of support. It's not the same as I've repeatedly stated in open court. I have a right to legal counsel. I request legal counsel. One was not given. This is an obvious bias by the court against me. And because of this whole situation, you have to put yourself in my shoes. Would you like to go to trial and have your attorney quit at the last minute and a judge deny you legal counsel? Now, if you're an attorney, I'm that issue. But if you're not, I'm not. It makes a difference. And if somebody's shooting at you and your family, and you know that you've got an opportunity to stop it, to preserve their life? Do you want to know that you'll go to jail if you try to stop the threat? Your only option is to call 911 and sit there and they're coming in the door. I've got a phone and a Bible and a baseball bat and a shotgun. Well, if I call 911, I'm going to die, but I know I won't get prosecuted. If I pick up the Bible, there might be divine intervention. The reality is, Jesus said in later days, first he sent them out and said, you don't need anything. You don't need a script. You don't need any money. Your needs will be provided for, and they were. But in the end, he said, if you don't have a robe, if you don't have a gun, sell your robe and buy a gun. Because he knew in those days, you had to be ready to protect yourself. Jesus was a very common sense man. He understood times were changing. The reality is, folks, you'll decide today whether people can still enact citizen arrest in this state, or if they will go to jail and not be able to provide for their family, because you're not supposed to defend yourself. You're supposed to run and call 911. Well, the reality is there's still a few men out there. And I hope we have some ladies and men on the jury that have the courage to think through all the information being provided and realize that justice in this case would only be served in a not guilty verdict on all counts. And you'll also have to ask yourself, if they gave you jury instructions saying, hey, we're going to now include lesser offenses, it's like, why all of a sudden would they now want to let the jury consider lesser offenses? Only because they don't feel they've got a strong case. Think about these things. And I ask that you come back with a not guilty verdict.
Ladies and gentlemen, we do live in a free country. And you're entitled to entertain every harebrained idea, every nutty idea that you want to. It's a free country. Mr. Parsons is a most dangerous of people, I submit, under all evidence. He's what you call a true believer. And you have heard him in the last few minutes address. He's very calm. You're given an opportunity to contrast that with the real Mike Parsons on this tape. Mike Parsons, lives in a fantasy world, I suggest, from all the evidence. It's a free country. You can believe any nutty idea. But this goes to whether somebody's to be believed, their version of reality. He lives in a fantasy world where you don't have to pay federal income tax. You don't have to have a driver's license to drive. Jesus apparently said, sell your robe and buy a gun. You treat animals like people and people like animals. Well, you can believe all this, except where it affects your ability to perceive reality. Mike Parsons' reality is not the reality of Mr. Laxton, Mr. King. And ultimately, your decision is who we believe. Who do we believe? Nowhere, I suggest, is there any evidence. If you believe that Mr. Laxton committed felony, killing what he thought in his mind was a wolf, it suggested it was a felony. I suggest there's no evidence of that. There's been absolutely no evidence of any crime perceived to have been committed by Nick King. I suggest there's no evidence at all Mr. Laxton did anything to defend himself, but Mr. Parsons cannot even suggest to you any kind of even far-fetched reason as to why Nick King could be arrested. And a citizen's arrest, the judge will tell you, you don't have to listen to Mr. Parsons or me, the judge will tell you when a citizen can effect an arrest. And to use deadly force, such as was done here, there has to be self-defense. There is no self-defense. That's the bottom line. He, Mr. Parsons, was not exercising self-defense. He was just mad that his wolf got shot. He took the law into his own hands. Now, ultimately, it's always up to you, ladies and gentlemen of the jury. And if the state has not carried its burden of proof, you by your verdict can send him back to his family to go to the south part of the county on Hughes Road, where he can continue to be the citizen enforcer of all laws. But if the state has carried its burden of proof, which I suggest to you, you need to do your duty. Now, aggravated kidnapping is a substantial interference, and the judge will tell you what it is, and a confinement of you. And for dramatic purposes, I am going to, for 30 seconds, say nothing. At the conclusion of that, I'm going to play, or have played, the exhibit of what this encounter is. And I want you to think, it's 30 seconds. Is that a painful silence? Time? Is it a painful silence? Are you somewhat embarrassed? Is it somewhat awkward? And multiply that by 8, and that's 4 minutes. And multiply that by having a gun pointed at you, not in a play, not in a movie, but in real life, and you don't know whether you're going to live or die. And I want you to think, is that a substantial interference with my liberty? And I'll now wait for 30 seconds. .5 minutes.
Where's the other dog? He done shot and killed one of them, Pat. Burnett, son of a bitch, is down here. Where's my other dog? Where's my other dog? Where's your gun at? Drop your gun. Drop your gun. Turn around. Turn around. On the ground, sir. On the ground. On the ground. You're under arrest. On the ground. I'll shoot you. Put your gun on the ground. You two on the ground. Now you will be shot. 5, 4, 3, 2. Put your gun on the ground. Don't come out. Turn around. Put the gun down. You're under arrest. That's fine. Both of you. Put the gun over there. No. You're under arrest. That's fine. It don't matter. I have a right. Don't turn around. That gun on me. Turn around. Put the gun down. You grab the gun, I'm going to shoot. Get away from the truck. Get away from the truck. Get over there. Put the gun down, damn it. Put your gun down. Turn around. Put the gun down. Where's the other dogs at? Hey, I don't know, dude. Where's the other dogs at? Face down. No, not. The citizen's arrest. You're under arrest. That's fine. Put the gun down. Lay down. Lay down. Put the gun down. Lay down. Lay down. Put the gun down. Lay down. Lay down. Put the gun down. Lay down. Where's the other dog? I want the other dog. The dog ran that way. Did you shoot her? I didn't shoot shit. I'm working. Did he shoot her? I'm working right here. I don't know. He's a grown man. You're involved in it too. You're a witness. Put the gun down. No, you're both under arrest. I don't give a shit. Yes, ma'am. I need a. You're both under arrest. I'm not in Hughes Road. I'm being held at. Now, Mike Parsons has a citizen's arrest on these two. They're different. They broke the law. Put the gun down. No, you. I ain't in Tipping County Road. That's Philly County. Stay back. Where's the gun at? Where's your gun at? I found a holster. Where's your gun? Where's your gun at? Where's your gun at? Where's your gun at? Back up. Where's your gun at? Where's your gun at? Don't touch that. Where's your gun at? Put the gun down. Where's your gun at? Gun down. No, where's your gun at? Put the gun down. I'm not going to until you tell me where your gun is. Pull it out. Pull it out. Put it on the ground. What? Is it right? Put the gun down. If you pull it out, what? Put the gun down. If you pull it out, what? I'm not pulling the gun out. If you pull it out, what did you say? You're going to shoot me? No, put the gun. What did you say? Put the gun down. What did you say? Put the gun down. What did you say? I don't care. What did you say? Put the gun down. No. You're under arrest, dude. You don't understand. You have to stop. You understand you're under arrest?
Yeah, no.
You're under arrest. I do as assistant. They done shot one of them. She's dead out here in the field. Who are you?
Huh?
What's your name?
You get the law down here. And
What's your name? Back up.
You don't worry about it.
Yeah, I won't worry about it. You're gonna worry about it.
No.
Yeah, you are.
No, take them songs that you put up.
It's a female. It's what's her name? Gray. Brandy. Yeah, he killed Brandy. Yeah, come on down here in the field to get her. Bye. Where's your gun at? Don't come around this corner. Go to hell, son of a bitch. Follow me, you son of a bitch. You're going to jail. Follow me, son of a bitch. You're going to jail. You shot and killed my pet.
That's all.
In a few minutes, you'll be going back to the jury room to discuss the case among yourselves and to reach a decision. I'm required by law to read to you instructions or guidance, not on what your verdict should be, but on the law that applies and how you proceed in your deliberations. The defendant is charged in a multi-count indictment. He's charged with aggravated kidnapping of Nick King, the aggravated kidnapping of Barry Laxton, aggravated assault of Nick King, aggravated assault of Barry Laxton, burglary of a vehicle, and theft in 2 counts. Each charge must be given separate consideration. Some of these offenses include lesser offenses. Anytime someone is charged with a criminal offense, the court has a duty to charge lesser offenses. The defendant has entered a plea of not guilty to all charges embraced in the indictment. The evidence and arguments have been completed. The law that applies is stated in these instructions. The order in which the instructions are given is not an indication of the relative importance. You should not single out one to the exclusion of another, but need to consider each in light of and in harmony with the others. The indictment is a form of an accusation charging the defendant with these crimes. It's not evidence against the defendant, does not create any inference of guilt. At times during the trial, I've ruled upon the admissibility of evidence. Please do not concern yourself with those rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts, or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You're the exclusive judges of the facts in this case. Also, you're the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all the evidence in the light of your own observations and experiences in life. The law presumes the defendant to be innocent of all charges against him. That presumption remains with him throughout each stage of the trial and is not overcome unless from the evidence in the case you're convinced beyond reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. That burden remains on the state throughout the trial of the case. A defendant is not required to prove his innocence. The burden is on the state to prove by a preponderance of an evidence that an offense was committed in Tipton County, Tennessee. Proof by a preponderance of the evidence means the great weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that an offense was commenced or consummated in Tipton County, Tennessee, then you must return a verdict of not guilty. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and is committed for the finding and returning of an indictment in this case. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after that investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge. Moral certainty is required, and that certainty is required as to each element of proof necessary to constitute the offense. The defendant is charged in 2 counts with aggravated kidnapping. For you to find the defendant guilty of aggravated kidnapping, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And number 2, that the defendant possessed or threatened the use of a deadly weapon. And confinement is unlawful if it is accompanied by force, threat, or fraud. Deadly weapon means a firearm or anything designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally or intent means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it's the person's conscious objective or desire to either engage in that conduct or cause the result. The lesser included offense of kidnapping. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant knowingly confined another unlawfully so as to interfere substantially with the other's liberty. And number 2, that the confinement was under circumstances that exposed the other to substantial risk of bodily injury. Again, the confinement is unlawful if it is accompanied by force or threat. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, physical pain, temporary illness, or impairment of function of any bodily organ. Force means compulsion by the use of physical power or violence. I've given you the definition of knowingly, and I've given you the definition of intentionally. There's also a lesser included offense of false imprisonment. For you to find the defendant guilty of false imprisonment, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number 1, the defendant removed or confined another unlawfully so as to interfere substantially with the other's liberty. And number 2, that the defendant acted knowingly. There's the lesser included offense of criminal attempt, that is, attempt to commit any one of those offenses. Any person who attempts to commit a criminal offense is guilty of a crime. If you to find the defendant guilty of criminal attempt, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant intended to commit the specific offense of aggravated kidnapping or false imprisonment. And number 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the offense under the circumstances that the defendant believed them to be at the time, and his acts constituted a substantial step toward the commission of that offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the offense. The essential elements necessary to constitute the offense have been previously set out in these instructions. The defendant is charged in 2 other counts with aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. If you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant intentionally or knowingly caused another to reasonably fear imminent bodily injury. And number 2, that the defendant used or displayed a deadly weapon. Deadly weapon, again, means a firearm or anything designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in its manner of its use or intended use is capable of causing death or serious bodily injury. I've given you the definitions of knowingly and intentionally. The lesser included offense of assault. For you to find the defendant guilty of assault, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant caused another to be in reasonable fear of imminent bodily injury. And number 2, that the defendant acted either intentionally or knowingly. Again, bodily injury means a cut, abrasion, bruise, burn, disfigurement. I've given the definition of knowingly and intentionally. The defendant is charged in another count with burglary of a vehicle. For you to find the defendant guilty of burglary of a vehicle, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant entered any passenger car, automobile, truck, trailer, boat, or other motor vehicle. And number two, that the defendant entered with the intent to commit theft. Theft is defined as stated in these instructions where the defendant knowingly obtained or exercised control over property owned by another without the owner's effective consent with the intent to deprive the owner of the property. And number three, that the defendant acted without the effective consent of the owner. And number four, that the defendant acted either intentionally, knowingly, or recklessly. Enter means an intrusion of any part of the body, or an intrusion of any object in physical contact with the body, or of any object controlled by remote control, electronic or otherwise. Effective consent means assent in fact, whether express or apparent. Consent is not effective when induced by coercion. I've given you the definition of intentionally and knowingly. The legal definition of recklessly means that a person acts recklessly with respect to the circumstances around the conduct, where the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The defendant is charged in two of the counts with theft. Any person who commits the offense of theft of property is guilty of a crime. If you find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant knowingly obtained or exercised control over property owned in count 6 by Nick King or in count 7 by Barry Laxton. And number two, that the defendant did not have the owner's effective consent. And number three, that the defendant intended to deprive the owner of the property. I've given you the definition of knowingly and intentionally. Obtain means to bring about a transfer or purported transfer. Obtain includes but is not limited to the taking or carrying away of the property. Exercise control over property is defined as the right to direct how that property can be used or disposed of. Property means anything of value, included but not limited to personal property. Owner means the person other than the defendant who has possession of or an interest in that property. Effective consent means assent in fact, whether expressed or apparent. Deprive means to withhold the property from the owner permanently or for such a period of time as to substantially diminish the value or enjoyment of the property, or to withhold the property or cause it to be withheld for the purpose of restoring it only upon the payment of reward or other compensation, or to dispose of the property or use or transfer any interest in it under circumstances that makes its restoration unlikely. Included in the defendant's plea of not guilty is his plea of self-defense. If the defendant was not engaged in unlawful activity, and if the defendant was in a place where he had a right to be, he would have no duty to retreat before threatening or using force against the alleged victim. When and to the degree the defendant reasonably believed the force was immediately necessary to protect against the alleged victim's use or attempted use of unlawful force. If the defendant was not engaged in unlawful activity and was in a place where he had a right to be, he would also have no duty to retreat before threatening or using force intended or likely to cause serious bodily injury. If the defendant had a reasonable belief that there was an immediate danger of death or serious bodily injury, the danger creating the belief of imminent death or serious bodily injury was real or honestly believed to be real at the time, and the belief or danger was founded upon reasonable grounds. In determining whether the defendant's threat of force in defending himself was reasonable, you may consider not only his threat or use of force, but also all the facts and circumstances surrounding and leading up to it. Factors to consider in deciding whether there was reasonable grounds for the defendant to fear death or serious bodily injury from the alleged victim include, but are not limited to, any previous threats of the alleged victim made known to the defendant, the character of the alleged victim for violence when known to the defendant, the animosity of the alleged victim for the defendant is revealed to the defendant by previous acts and words of the alleged victim, and the manner in which the parties were armed in the relative strengths and sizes. The threat of force against the alleged victim would not be justified if the defendant provoked the alleged victim's use or attempted use of unlawful force, unless the defendant abandoned the encounter or clearly communicated to the alleged victim the intent to do so, and the alleged victim nevertheless continued to use unlawful force against the defendant. Force means compulsion by the use of physical power or violence. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Imminent means near at hand, on the point of happening. Serious bodily injury means bodily injury that involves a substantial risk of death. Protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement. Bodily injury includes a cut, abrasion, or bruise. If evidence is introduced supporting self-defense, the burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. If from all the facts and circumstances you find the defendant acted in self-defense, or if you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. Citizen's arrest. This is referred to as arrest by a private person. A private person may arrest another for a public offense committed in the arresting person's presence. When the person arrested has committed a felony, although not in the arresting person's presence, or when a felony has been committed and the arresting person has reasonable cause to believe that the person arrested committed the felony. A private person making an arrest shall, at the time of the arrest, inform the person arrested of the cause of the arrest, unless the person is in the actual commission of the offense. To make a citizen's arrest, a citizen is not required to be 100% certain that the suspect is guilty of the crime. The citizen is required to have probable cause to believe that the suspect has committed a crime. A private person who has arrested another for a public offense shall, without unnecessary delay, take the arrested person before a magistrate or deliver the arrested person to a law enforcement officer. A private person, in making an arrest authorized by law, may use force reasonably necessary to accomplish the arrest of an individual who either flees or resists that arrest, provided that a person cannot use or cannot threaten to use deadly force, except to the extent authorized under the self-defense law. Probable cause to believe that arrest was committed will not justify an arrest by a private person when, in fact, no offense was committed. A private person makes or attempts to make an arrest at his own peril. A citizen's authority to effectuate a citizen's arrest does not permit the citizen to violate the law. For example, a citizen attempting to effectuate a citizen's arrest may be properly convicted of speeding while attempting to effectuate the arrest, because the citizen's authority to effectuate an arrest does not allow the citizen to violate the law. The owner of a dog has a duty to keep that dog under reasonable control at all times and to keep that dog from running at large. Evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by either direct evidence, circumstantial evidence, or both combined. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of the testimony of a person who has perceived by the means of his or her senses the existence of the fact sought to prove. That is, if a witness testified about what they themselves saw or heard, they presented direct evidence. Circumstantial evidence is all the other testimony and exhibits that give you clues about what happened in an indirect way. It consists of proof of collateral facts and circumstances which do not directly prove a fact in issue, but from which that fact may be logically inferred. When the evidence is made up entirely of circumstantial evidence, then before you be justified in finding the defendant guilty, you must find all essential facts are consistent with the theory of guilt, as that is compared with all the facts proved. The facts must exclude the other reasonable theories of hypothesis except that of guilt, and the facts must establish such a certainty of guilt that the defendant as to convince the mind beyond a reasonable doubt that the defendant is the one who committed the offense. It's not necessary that each particular fact should be proved beyond a reasonable doubt. If enough facts are proved to satisfy the jury beyond a reasonable doubt of all the facts necessary to constitute the crime charged. Before a verdict of guilt is justified, the circumstances taken together must be of the nature and tendency leading on the whole to a satisfactory conclusion and producing, in effect, a moral certainty that the defendant and no one else committed the offense. I've charged you regarding some inferences you may make in regard to the evidence. That is, you may make certain inferences in regard to the evidence. However, you're not required to make inferences. It's within the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant any inferences which the law permits you to draw. Inferences may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut any inferences raised, you should consider that explanation along with all the other evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt each element of the offense before a defendant can be found guilty. You should consider all the evidence presented in this case and give it an impartial consideration. Part of your responsibility is to determine what the facts are based upon what you heard from the witnesses. If there are conflicts in the testimony of the different witnesses, it's your duty to reconcile them if you can. The law presents